Hi everyone, and welcome to today's session on understanding designs. My name is Liam. I'm with the Communication and Experience team here at IP Australia. Without any further ado, I'll hand over to our presenters today, Derek and Sarah, to introduce themselves, and we'll get underway.
Afternoon everyone, my name is Derek White. I'm joined by my colleague Sarah Patton. We're both from the designs team. We'll be taking you through some of the basics of applying for what a design is and how to apply for one, and what you might like to do with it. Feel free to put your questions in and we'll get to them if we can. And with that, let's get Sarah to start.
Hey everyone, my name is Sarah. I'm a designs examiner. I'm just going to start off, just give you guys a quick rundown on what IP Australia is. So basically our primary function is that we administer patents, trademarks, designs, and the plant breeders' rights system. But we also do a lot of stuff related to that. So things like these webinars, we do public education and awareness programs to educate people about what IP is. And we contribute to government and policy negotiations and advice. So basically anything related to IP and the IP rights that can be registered, we have a hand in. What do I mean when I say IP? So it stands for intellectual property, and that can include the application of the mind to develop something new or original. So it can exist in various forms, including new inventions, which are likely to be a patent, brands, which can be a trademark, designs, which we're talking about today, and stuff like artistic creations as well. So this webinar is solely going to be focused on designs. If you do have an interest in more than one IP right, please check out our website. We also have other webinars on there, including an IP 101 if you just want a quick understanding of the different types. So before we get into the nitty-gritty of what a design is, I thought it'd be important to talk about whether or not registration of a design right is the right option for you. And there are both positive and negatives depending on your situation. So it's going to be an individual situation for everyone. But there are benefits. If you do have registered right, you can protect from copycats because it is legally enforceable. It can support further R&D from others by sharing stuff. And it can be a valuable business asset that can open up new opportunities and revenue streams. But it is also important to note that it is not the right for everyone. The costs can be high. Costs to apply for a design, there is a monetary value. And also to enforce a design, it can actually cost money. And some designs and artistic creations can be protected by other unregistered rights, such as copyright, which we will touch on a bit later. And so you may have better luck going with something like that. But if you are interested in a design, this is what we're talking about when we talk about a design right. So our Act defines a design as protecting the overall appearance of a product, so resulting from one or more visual features of that product. So when we say product, we mean something that is manufactured or handmade. And the visual features refer to the shape, pattern, configuration, or ornamentation of that product. Design registration is intended to protect designs which have an industrial or commercial use. So something you want to commercialize. If you've made something just for yourself and you're not looking at selling that or commercializing that, you probably don't need a design right. But if it is something that you want to manufacture and get out into the marketplace, then a design right might be something you're looking for. Design registration lasts for 5 years, and it can be renewable up to 10 years. So you can have 10 years of protection. So when we talk about visual features, which is what you get protection for, this doesn't include how a product feels or what material it's made out of. It's concerned solely with what it looks like. So your product has to be something that can be visually represented. Not just an idea or something like that. It needs to be a physical product that you can show. You can't apply for a logo. So we get a few people that try to put in logos. Generally, they're looking for a trademark, which is something you can. You need to, if you do want a trademark, you need to specify the goods and services you want that trademark to protect anyway. We need a physical product for it to be considered a registered design. And registration of a design right is valid across all of Australia. If you do want to look at international registration, you're going to have to look at the different agencies. That's something that we'll cover a little bit later as well. This is a really good example of a registered design right. Some of you may recognize it. It's one of Dyson's handheld vacuum cleaner models. So it was filed and registered in 2013, and it was certified in 2014. And it's a really good example of how design rights are concerned with only the visual features. So while Dyson have fancy cyclonic actions and their vacuum cleaners all use special technology that they like to protect, the design right doesn't protect that. This design right just protects what this vacuum cleaner looks like. How it works is likely to be protected by a patent, so that's a different type of protection. So this is a really good example of what we're looking for with a good design application. So you can see there the images are clear. There's a few of them showing it from different sides. They show the different visual features so we can see what the full thing looks like. So each of those pictures will be filed on a different page, and there's not a lot of extra text there. So there's only labels that say side view, front view. We don't want anything else other than that. We don't care about the size. We don't care about what this particular part is made of. We don't want any extra material when you file your design application on these representations. We want it as clear as possible so we can see the actual product that you want protection for. We do allow a schedule of representations. So if you'd like to submit something at the end saying, this first picture shows from this angle, the second picture shows from this angle, that's acceptable. But generally, we just want to see a really clear view of the product you want protected, and we don't want any other information that's going to confuse that. For another example, this one you might recognize is Bodum. This is a logo, and on its own, it is not capable of being a registered design. It's because it's not applied to a product. So Bodum do have this registered as a trademark, and that's fine as a trademark. But this is an example of Bodum's registered design. So you can see that they've put that logo on the actual grill product, and they have protection for the barbecue grill as a whole. And it's another really good example of a well-filed application that has good views where you can see the product clearly and there's no extra information in there that's going to confuse it. They've just labeled the views and they have clear pictures or drawings of what the product looks like. There are some other examples that I can think of off the top of my head. We have Keep Cup. So Keep Cup make the cups, reusable cups. So Keep Cup is their trademark and they have that protected, the name, and they also have a slightly stylized logo version registered. And they have, as far as design protection, the shape of the cup is protected. And we have a bunch of stuff on our register, things like Zimmermann. So Zimmermann is obviously the trademark and the trade branding, and they have a few of their dresses and clothes protected as a design right. So they're getting design protection for the shape of that clothing item. So what are the benefits of getting a registered design? So once you have a registered design, this gives the owner exclusive rights to commercially use, license, or sell it. And it can be a valuable commercial asset. It gives you protection for the visual feature of the product, but not how it works. So if you think you've come up with something that looks unique and you want to protect that look, design registration may be something you're interested in getting. It does provide an exclusive right to prevent others from using, and you can authorize certain people to use your design, so it can give you protection in that way. And if you get a certified design, you are actually able to enforce that design to stop other people from using this. We'll talk briefly about certified designs a bit later and the difference between registered and certified. I think Derek's going to talk briefly about the application process.
Yep, thanks, Sarah. I might talk about registration and certification at the moment. Seems to be a good time to do it. So designs can be confusing for people because they're not a very well-known IP right. We do get quite a lot of people who are not quite sure how they work. So one of the things that confuses people a lot is the difference between registration and certification. So designs is a two-step process. The second step is an optional step that some designs owners decide to take, but not all. So the first step is getting your application in, and once it gets through our formalities check, which is essentially just making sure that we can see what the design is correctly, it's got all the I's dotted and all the T's crossed, that will get you a registered design. It doesn't give you, it doesn't make it through an examination process, and it doesn't necessarily give you an enforceable right. So what registration gives you is it protects your design for 5 years. And as Sarah mentioned, it can be renewed for a further 5 years. But what the main thing it does is establish the priority date, which is the date that you've put people on notice saying this is your design and that you claim ownership of it. The reason for the two-step process is to help keep fees down. So registration doesn't go through the examination process, and it doesn't guarantee you a win if someone challenges your registered design. It does give you protection for the overall appearance of your product. It gives you rights to exclusively use, license, sell the design. And the main one is it gives you the option to request examination for the purpose of getting a certified design. So with certification, the optional step I've mentioned, once your design has been registered, you can request for it then to be examined. And if it makes it through the examination process, it'll result in you having a certified design. So the big difference is a certified design is legally enforceable, unlike the registered design. So the benefits of that is if someone else uses your design or something that's substantially similar to it without your permission, you will be able to take action and hopefully stop them. So you can only do that if your design is certified. So a bit about the application process before we can get your design to registered and potentially certified status is that you can see a bit of a flow chart on the screen showing the sort of the smooth path of an ideal design application. It won't always look like this. It can become quite complex, but this is a nice easy flow chart to follow through. So after you file your application will check that it's met our minimum filing requirements at the formalities check. We'll make sure that you have given us all the relevant information we need to publish it on our register. We'll also send you a notice telling you what the design number is, what your filing date is, and all those sort of administration type things. At that point, when you receive that, please make sure that the information is correct. If it's not, get in touch with us. It's a really good time to sort out any discrepancies. Sometimes, if you leave that too late, it can be difficult to fix issues with your design application. So the formalities check, we run through, make sure that your name, address, designer names, all the ownership issues are correct and present. We also check that you have provided us with sufficient representations or pictures of your design for us to be able to see what it is and make sure that it's a suitable thing to be published and registered. Like I mentioned, registration doesn't give you the enforceable right, but we need to make sure at this stage that we've got enough information there that if you do decide to get it certified, that we've got all the information to allow us to complete the examination and certify it. So some tips for getting your application right. There's a few areas that people regularly make mistakes. We see these quite a lot. Those tend to be with the ownership. So owners for all IP rights must have legal personality, and that generally means that it's a person. It can be a registered company, it can be a body corporate, but for designs in particular, it can't be a trust, and a business name is usually not enough either, unless that business name is also the same as your registered company. Applications can have more than one owner, but if that's the case, they all must have legal personality. So for most people, it's either a company name or the name of a person or persons. That's the owner. The product name. So you need to give us a product name so that we can establish what the product is that you're claiming, and we need to ensure that the product name aligns to the representations or the pictures that you've given us. So for example, the examples that Sarah showed earlier, the Dyson vacuum cleaner, it wasn't a whole vacuum cleaner, it was just sort of the body of it. So the name of that one, it was really simple. We want these to be really generic. The name of that one was part of a vacuum cleaner. Simply just describes what it is. It doesn't say it's a Dyson vacuum cleaner. It doesn't say it's a cyclonic action body of a vacuum cleaner. Simply part of a vacuum cleaner, and that's plenty. That was sufficient for that one. Similarly, with the Bodum example, when the trademark was applied to the barbecue grill, the product name for that one was simply barbecue grill. Nice and simple, purely descriptive. We don't want trademarks. We don't want complicated descriptions of what the product is. Simply it's a generic description of what your product is, so that we can correctly classify it and ensure that if it does go through examination, we know exactly what we're looking for to give you the best chance of being able to get your design certified and to enforce it. So then the last place that people tend to go wrong with their applications, and this is very common, is with the representations. So when I'm talking about representations, I mean the pictures. So the examples that Sarah showed before, where they had various drawings of the designs. It doesn't have to be a drawing, but drawings are very popular. If it is a drawing, it needs to be nice and clear. Usually computer-aided drawings are the ones that we get. They're usually nice and clear. If you are hand drawing it, it can't be sort of sketchy. We need good solid lines. We can also accept photographs, and they can be really useful depending on what it is your design is. So we've had various different things for something like the vacuum cleaner and the grill. Those things have clearly been designed, and the applicant has given us the drawings that have come out as part of that process, and that's great. They were nice and clear. They show all of the visual features. Other things, so things I've seen have been that might require a photograph. We've had one of the ones I've seen that was really good with a photograph was a really large structure that was made for holding and cleaning and inspecting shipping containers. So it was something that was potentially put together on site. And I think it was potentially just a prototype, but they've decided to register it. And whilst they might not necessarily have drawings, they could take a photograph of it. What was important with that one is that they took a photograph with a nice neutral background, because we need a neutral background. There can't be all sorts of things in the background that would interrupt our understanding of what the design is, or anyone else's understanding of what the design is. So your representations will be published on the register once your design gets to the registered stage, and everyone will be able to view that. They're publicly available. And what the ideal is that people will be able to look at your design, at your representations, and see what your design is. That helps them make their own decisions about their own designs and making sure that they're not infringing on yours or getting something that's too close to what someone else has already applied for. So with the application process, some of the best things to do. The first thing is to do some searching. This is doing your homework. You can do this yourself, and starting yourself is probably the best idea. Even if you do decide to get an IP professional to help at some point, giving yourself a head start by doing some Google searches, looking around yourself at your industry, magazines, industry publications, or on the internet to see what else is out there. If there's any other designs that look like yours, that might be something to have a chat to with an expert. That might be an IP professional. That might be an attorney who specializes in designs or who is familiar with designs. So places you can look to find these things are on our database, the Australian Design Search. International databases, most international or many international offices publish their database like we do. Not all do, but most do. Particularly relevant are markets where you might be deciding to sell your product. Other places to look are all over Google, all over social media, so Facebook, Twitter, Instagram, anywhere else where people are sharing images that might be that might have images of products that are similar to yours. The second thing is to just develop your strategy. So consider if you're going to have variations on your design. If you are, can think about if you're going to file them all at once. There are a number of different ways to do this, and it can be slightly complicated. So an IP professional who is familiar with and specializes in design would be an excellent person to talk to about this kind of thing. You can block yourself with your own earlier designs applications if you don't do things in the right order or at the same time. So by that I mean, if you file for one design and then the next week or the next month or the next year you file for a design that is very similar, your earlier one might block you. Even though it's yours, it might block you from getting your other design in. So if you're going to have file for a bunch of similar designs, it can be useful to file them all at the same time. And lastly, you submit your application. So using our online services, it will step you through how to apply and how to pay the appropriate fees. And at that point, part of the application process on the online services is you have to choose whether you want to just register your design for now, whether you want to go ahead with registration and straight into examination, which some people do, and I'll talk a little bit more about that again. Or the third choice is publication, and I'll talk about publication in a second. So you have to choose one of those three options, either when you apply or within 6 months of filing your application. If you don't do it within that 6 months, your application will lapse. So I mentioned publication there. Publication is an option, but it's not a very commonly used one, and it will be getting phased out over the next couple of years. So requesting publication means that you don't get any rights in your design, but it puts it on our register and essentially is something that people can do for strategic purposes, making sure that it gets out there. It's putting people on notice that this design is published. It can be used as a defensive strategy if you can't register your design, and it's something that if you're considering, it's probably worth talking to an IP professional about, because if you do publish it, then you won't be able to get a certified design for that same design later on. So it's not a very commonly used option, but it is an option at the moment.
Just while we're talking about the designs application process, if I just interrupt, in that first part where you're doing your searching, please check out our website because we have recently updated it with a lot more information, including a checklist that you can step through. So there's a lot of information on our website if you do have any questions about the actual process as well. That can be a good resource.
Yeah, thanks, Sarah. Yeah, our website has been recently updated. Some of the pages will look similar if you've seen them before, but there's an awful lot more information, and hopefully it's a lot clearer than it has been previously. So this slide is really important. If you take away one thing from today's presentation, it should be this. If you are going to apply for a design, or if you think you might want to apply for a design, don't publish it. That means don't put it on your website, don't put it on your Facebook, on your Insta, anywhere. The main thing that will stop people getting a certified design, and this happens 8 or 9 times out of 10, where we find problems, is that they've pre-published themselves. So it's really important with designs that if it's going to be certified, it needs to be examined, and the process we go through to that is that we search for your design, and if we find it and it's been published before the date that you've applied for it, or in certain situations, if you have an earlier date that you can claim, then that will probably invalidate your design. Simply speaking, there's a little bit more to it, but essentially, if you publish it before you apply for it, and we find it, you won't be able to get it certified, which means you won't be able to get it registered, and you will lose. Sorry, you won't be able to get it certified, so you won't be able to enforce it, and you will lose your registered design. So that's the main. That's really key. That happens so often, and it's devastating for people who have applied for things. And as examiners, we see this reasonably often, and it's not great for us either. We want people to be able to enforce their designs. We want to help people certify their designs and get them protected. So when we receive examinations and we start looking at the applicant's website, at their Facebook, and the design is plastered all over it before they've applied, that usually means it's all over for that design. And just a note that if that does happen, there won't be any refunds because your fees are for our examination. And if you receive an adverse finding in that, that's unfortunate, but that's how it goes. So that's the main thing with designs. Keep them under your hat until you have applied. So Sarah mentioned a little bit about international protection earlier. Applying through IP Australia for a design essentially just covers you for Australia. So you can apply in different countries if you want international protection, but there's no one thing that covers you for all countries or for many countries. There is a process that some countries use that Australia is not part of that means you can use your application in one country to apply in many different countries, but that's not something that we do here. So if you do want to apply in various countries, you will need to consider which countries you want to apply in, and usually the way to do that is to apply separately to each country. Now there are various ways to go about that. Using the services of an IP professional who specializes in international designs applications would be an excellent idea. It can be very complicated and it can get quite expensive, especially if you don't get it right. Many countries have different systems to Australia. Australia's current system is a little bit out of step, well, a little bit different from many other countries in that we have the two-step process. Not all countries have that. You might also need documents translated. That could require the services of a technical translator. And if you're not a resident in certain countries, you might not be able to apply in those countries without using a local IP professional. So using a IP professional who specializes in international designs applications is really useful because they'll be able to tell you the ins and outs of what you will have to do in various countries, and they might be able to help you find local representation in those countries if you require it. The fees for different countries will also vary quite a bit. So like I said, the fees can add up and they can become quite expensive once you're adding a few countries. So make sure that you talk to someone who knows what they're doing before starting to apply in various countries. One thing you can do with your overseas applications is that you can use your Australian application to claim the date that you filed in Australia as the date that you can claim in most overseas countries. Australia is part of the Paris Convention, which is an intellectual property convention, allowing you to essentially claim your date in various countries. Most major countries are party to this convention, so there are very few that you'll find that won't recognize the Paris Convention. The main thing with that one is you need to apply within 6 months of your original application. So if you apply in Australia today, you can use today's date to apply in various other countries and claim today's date, even if you apply in a few months' time, as long as you get it within 6 months' time. So, yeah. Designs rights, as Sarah mentioned, only last for 10 years, but they can be quite a strong right. They're quite a short-lived right, but they can be quite a strong right. So if someone copies your design, it's up to you to enforce it. IP Australia is not really in a position to help with that. We are essentially, we administer the designs rights and the Register and the Designs Act, but we can't really take sides in an infringement action. We can advise you to get legal advice, but we can't really tell you what to do in an infringement action. The best bet would be to talk to an IP professional again, especially someone who is a specialist in designs. They will be able to give you advice, and they will be able to help you decide on the best course of action. So a few things to remember though: a registered design is not enforceable until it's been examined and certified. So if you think someone has copied your design or is infringing your design and you don't have a certified design, that would be the first thing to do. Talk to an IP professional, see if it does look like it's something that's enforceable, see if it's something that you think they might think can be defended, and before you start any kind of enforcement action, make sure you get that design right certified. So the case on the screen, this is an actual case from fan on the left, was registered and certified in 2012, and the owner later discovered that someone was importing and selling the fans on the right. So they took them out of the court, and even though the fans there they're not identical, the court decided that they have, whilst they've got a number of obvious differences, they also have significant and eye-catching similarities. And the court found that it created an overall impression of substantial similarity, which meant that the fans on the right, being imported into Australia, infringed on the registered and certified design on the left. So the owner was then able to seek financial relief and based on the infringing fan and stop the infringement happening. So as you can see, they're not identical, and at first glance you might think that those fans are wildly different, but like I said, designs can be quite a strong right. So the fan on the left was correctly applied for, had it certified, so it was all ready to go, and they could move swiftly and show that they've got a enforceable right, which then stood up in court. Another area that can be quite complicated in designs is there is a bit of an overlap between the Designs Act and the Copyright Act. So IP Australia doesn't administer copyright, so I can only really give you sort of general information about copyright, and the overlap with designs and copyright is quite a complex area of law, but we'll mention it here and hopefully you can avoid some of the main pitfalls. So as it says on the screen, copyright generally doesn't protect functional items. And I say generally, there are exceptions. There's a lot of exceptions, and the Copyright Act and the Designs Act, the interactions can be confusing. So generally, it doesn't protect functional items, whereas that's exactly what the Designs Act is for. So if you have a 2D work or a work of artistic craftsmanship, which is a term I'll go into in a minute, or a design for an item that you haven't yet started to exploit commercially, you might be covered by copyright. If you are covered by copyright, you, in many cases, will lose that protection once your design has been registered under the Designs Act. Or if you don't register it, even if you don't register it, you'll probably lose that protection if your design has been industrially applied, which essentially means you're making it and selling it. The Copyright talks about 50 products, but that can be lower for certain products. So if you're making large, complicated products, it might be less than that before it's been decided that you've industrially applied it. So the type of material protected by copyright includes artistic works, and there are 3 categories of material which are classified as artistic works. Generally, it's paintings, sculptures, drawings, engravings, and photographs. Things that are often generally just thought of as art. So things that you would go to a gallery to see are generally protected under copyright. Buildings and models of buildings are also generally protected under copyright. And one I mentioned earlier are works of artistic craftsmanship. So works of artistic craftsmanship are usually something that's decided in court by experts, and it's often something that's using the materials in such a way that it really emphasizes the material's properties and things like that. It's a complicated definition, and it's something that we can't just decide, oh, my product is a work of artistic craftsmanship, therefore it can have copyright protection. So that's not something that the owner decides, that's something that's usually tested in court. So, but generally, if the product has been produced with the intention to sell it, it's unlikely that you can rely solely on copyright. If the product has been created for a commercial purpose, it's offered for sale, sold for profit, it's considered a product that's been industrially applied. It'll lose the copyright protection, and that's where it's really important that you need to have had your product covered by a designs application. So with this, all of the IP rights kind of work together. So you might have a product that could be covered by a patent, it could be covered by a design, it could be covered by a trademark, and potentially it might have been covered by copyright, or it might still be covered by copyright all at once. So all of the IP rights tie in together. And particularly designs and trademarks can work really strongly together. So for example, if a designer comes up with a design for a lamp, they protect the design for it. Other people might still search and see that design, think it's great, and start infringing it. And if the designer doesn't notice, or it's being used as a replica, which is a whole other area we won't get into today, people can look online and they might Google your trademark or your name if you've come up with that lamp and find replicas. One thing you can do with that is if you protect your brand or your name as a trademark, it becomes more difficult to do. So for example, if you can't describe a product as a replica David Trubridge lamp because that David Trubridge has been protected as a trademark, it just becomes a replica pendant lamp, which is much harder for people to find and makes it more difficult for replica makers to actually sell their products because you've tied up more of your rights in different IP rights.
So that does bring us to the end of the main presentation. Well, thank you, Derek. Thank you, Sarah. Thank you, audience. We'll see you on the next one.